This conference is wonderfully interdisciplinary. You have heard from law and philosophy. I will speak now for politics. The charter of the Nuremberg Tribunal and the UN Charter and General Assembly Resolution 3314 define aggression as a crime and give some sense of the nature of the crime. But the definitions, as we've been told, are minimalist, and there isn't a history thick with illustrative legal cases. There have been a lot of wars since 1945. Which ones have been wars of aggression? A good many probably fit the definition, but I'm inclined to think that only some of them can properly be called aggressive. The only ones that the UN has called aggressive are the North Korean invasion of the South and the later Chinese intervention. So far as I can tell, the word was not officially used with regard to the Iraqi invasion of Kuwait in 1990. Since World War II, no government officials have actually been charged with aggressive war. I can't attempt a legal analysis of the cases that might have been brought, but I think anyway that we need a moral political analysis first. There are good reasons why the development of just war theory preceded the development of the laws of war. Legal texts may only imperfectly and incompletely embody our moral ideas, but without moral ideas, we would not be able to write legal texts. So what is the specific wrong that constitutes aggression? Years ago, I argued that the wrong was to force people to fight and die in defense of the state that protects their common life and the territory on which that life is lived. It has to be lived somewhere. It's not just the crossing of the border that constitutes the wrong, but the threat to the community as a whole and to each of its members that the crossing signifies. And that's why, as I wrote then, there is a strange poverty in the language of international law. The equivalents of domestic assault, armed robbery, assault with intent to kill, murder in all its degrees have but one name. Every violation of the territorial integrity or political sovereignty of an independent state is called aggression. To be sure, the General Assembly's resolution holds that aggression is only, quote, the most serious and dangerous form of the illegal use of force, but no other forms are specified. And the list of acts that constitute aggression, though short, seems to include pretty much every imaginable use of force against another state. In a way, that's a sensible position. All these aggressive acts may well justify forceful resistance, and resistance necessarily puts lives at risk. Shakespeare makes the critical point in Henry V. For never two such kingdoms did contend without much fall of blood, whose guiltless drops are every one a woe, a sore complaint against him whose wrongs gives edge unto the swords that make such waste in brief mortality. But this argument hangs on the existence of a common life that is worth defending, and of a state that organizes and protects it. If the king's subjects are unwilling to fight for the kingdom, there'll be no fall of blood. And if the kingdom is a brutal tyranny, then it may not be the attacker whose wrongs we should worry about. Legal texts like the UN Charter do not and probably cannot recognize that the argument about aggression depends on a previous argument about political legitimacy. All independent states, and certainly all states that are members of the UN, have the same legal value. They do not, however, have the same moral value. And the judgments we make or should make when a particular state is attacked or invaded have more to do with the moral value of the state than with the brute fact of attack or invasion. That, at any rate, is what I want to argue today. And the argument will require that we distinguish aggressive border crossings from other kinds, which can be both just and unjust, legal and illegal. My chief interest is in border crossings that are unjust and probably illegal, but that don't amount to the crime of aggression. Now, I acknowledge that the we in question here is of uncertain dimension. Some people insist on the exclusive relevance of the brute fact. For them, any, quote, invasion or attack by the armed forces of a state on the territory of another state, unquote, is a criminal act of aggression. Those quoted words are from the General Assembly's resolution, and their crucial feature is that the capitalized state is unqualified by any political or moral adjectives. And again, this is a necessary feature of the UN definition, but it would require us to call invasions and attacks criminal aggression when some of us might want to praise the invaders and attackers or to criticize them in some other way. As a member of that latter group, I will try first to distinguish the criminally aggressive from the praiseworthy cases, and then, more important, to suggest that there may be a range of cases between these two. In Just and Unjust Wars, I made a somewhat similar argument by describing a set of exceptions to the legalist paradigm, which insists on the brute fact. And that still seems to be a good way of making the argument, but not the only way. Given the number of exceptions and the differences among them, we might think not of a single moral rule and a set of cases to which we don't want to apply the rule, but of a moral continuum, extending, say, from something like the German attack on Poland, a clear example of aggression, to something like the NATO defense of Kosovo, a just war in my view, with many points in between. Kosovo is a useful test case. I'll come back to it, and then I will look at the American war in Iraq. My project is to pluralize the language of condemnation and critique. It's a common feature of this language that single words like communist in the 1950s or terrorist today come to serve wide rhetorical purposes. Politicians find it convenient to call their opponents communists or terrorists, even though many of them don't fit any serious definition of those terms. But this is a practice that we should resist. The moral political world is complicated, and it needs a language that reflects its complications. And this is also true of the moral legal world, where aggressor is the word that everyone uses to condemn armed attacks, and yet there are armed attacks that we should certainly worry about and perhaps condemn that aren't usefully called aggressive. But why should we ever think that an attack against the sovereignty, territorial integrity, or political independence of another state is anything less than aggression? One good reason is that the attack is preemptive, directed against an imminent attack from the other side, one that is known with certainty to be coming and to be coming soon, so that the state that is preemptively attacked is already a criminal state. In contrast to preventive wars aimed at more distant and speculative threats, preemptive attacks are commonly justified, even though they fit the minimal definition of aggression. The right of preemption seems to be an implicit exception to what looks like a ban on striking first, or it's taken to derive directly from the right of self-defense, so that preemptive strikes sit, so to speak, alongside defensive wars. But my primary concern here is with an attack by State A against State B when B is not already engaged in planning an attack against A and possibly has no interest in any such attack now or in the future. Even so, I want to argue that if the attack by A has urgent humanitarian reasons, if it is aimed to stop mass murder or ethnic cleansing in State B, it would be wrong to call it aggression. We might think of this as another implicit exception. Murderous governments are not protected by the doctrine of sovereignty. Alternatively, wars in defense of others are morally similar to wars of self-defense. They are even more just, I would think, and so if there is a continuum, they might represent one of the end points. This is the argument for humanitarian intervention. It already appears in 19th century law books, and many students of international law would probably accept it, despite the fact that it has never been ratified by the UN. I have seen NATO's Kosovo intervention called an aggressive war, but most observers acknowledged its moral legitimacy. The German philosopher Jürgen Habermas called it illegal but morally necessary. And when those two judgments are joined, the illegality is already fading. The moral meaning of aggression requires that there is a common life being lived on this piece of territory which this state protects and which the attacking state puts at risk. We can see immediately how the Kosovo intervention fits the UN definition, but not the moral meaning. Kosovo was part of the sovereign state of Yugoslavia, ruled from Belgrade, and so the NATO attack was both an attack on Yugoslav territory and a challenge to Yugoslav sovereignty. But there was no common life shared by Serbs and Kosovars, nor did the Belgrade regime protect the common life or even the physical lives of the Kosovars. In 1999, indeed, it posed the greatest threat to both of them. Nor did NATO seek anything more than the end of that threat and the establishment of guarantees that it would not be renewed. NATO did not put the survival of the Serbian nation in jeopardy. Hence, the war was not, from a moral standpoint, an act of aggression. It also wasn't a wrong of any lesser sort. Its moral necessity was full justification. At the same time, as critics of the NATO war pointed out, mass murder was not actually in progress in Kosovo in 1999. There were killings and rapes designed to terrorize the population, but there was nothing comparable, say, to the massacres that took place in Rwanda in 1994 when no one intervened. In fact, things were probably not as bad as they had been in Bosnia a few years earlier. But the chief agent of mass murder and rape in Bosnia was also the chief military actor in Kosovo, and that has to be a large part of the war's justification. Even if we insist, as I would, that military interventions are only justified in extreme cases, the extremity of Bosnia made extremity seem imminent in Kosovo. And the shame that many people felt in the West for having stood by and watched what happened in Bosnia led them to make sure that it didn't happen again, as it seemed, as I think it was, about to do. Here, once more, is the argument for preemption, which has the form that I've already described. If self-defense is justifiable, then so is its preemptive version. If humanitarian intervention is justifiable, then so is its preemptive version. We are still at the far end of the continuum. We start to move along the continuum when we consider wars that cannot, with any certainty, be called morally necessary. So what about attacks on governments that have begun a program of persecution and terror that might one day end in mass murder, but isn't there yet? What about governments that have committed mass murder in the past and might or might not do so again? What about governments whose ordinary brutality stops short, well short, of mass murder? Is it possible to describe a series of wars and military interventions that are not aggressive, even though some of them might be unjust? We can think of military action in these latter cases as preventive intervention. And doesn't it follow, since preventive war aimed at a threat that may or may not materialize cannot be justified, so preventive intervention aimed at massacres that might or might not happen also cannot be justified. There's a difference here that's worth noting. Shifts in the balance of power that strengthen State A vis-a-vis State B may point to a distant danger of coercion or invasion. That's the classic armament for preventive war, but there's no immediate experience of injury. By contrast, the kinds of regimes that might or might not commit mass murder are already brutal and cruel, already injurious to many of their subjects. It seems to me that prevention is still wrong. Ordinary brutality is not a justification for military attack. If it were, there would be far more occasions than it is safe to have, and far too much waste in brief mortality. States cannot impose the risks of war on the citizens of other states except in cases of humanitarian urgency. That's the general rule. Should it be qualified by additional information? For example, when the argument for prevention begins with the fact that this regime has already already committed mass murder in the very recent past, and so can plausibly be said to pose a near future threat. This case might fall somewhere between prevention and preemption. I'm still inclined to insist on extremity in real time, right now, or a moment from now, as the sole justification for military action. The fact that past crimes and the likelihood of future crimes may provide occasions for the use of force short of war, the embargo and no-fly zones imposed on Iraq after the first Gulf War and after the massacre of Shiites in the South are illustrative examples, but that's not my subject here. I want to focus only on armies marching across borders, bombers flying over cities. So imagine an attack of this latter kind, called preventive, against a tyrannical and brutal, but not at that moment murderous regime. Attacks like this are unjust, but do they constitute the crime of aggression? One way to address this question is to consider the intentions of the attackers. Of course, intentions are hard to figure out, even with regard to you and me, to people we know. They are harder with regard to states and governments, which are collections of interacting individuals. In the classic cases of aggression, Germany invades Poland, Italy invades Ethiopia, the crucial intention is conquest and subordination, which with great clarity puts the common life of the victim nation at risk. In the classic cases of humanitarian intervention, Vietnam invades Cambodia, India invades East Pakistan, the crucial intention is to stop the killing. But these are never the only intentions. So does it matter in either of these sets of cases if other intentions are present? If motives are mixed, as they always are in political life? Not, it seems to me, if what I've called the crucial intention is actually in place. Additional motives might lead us to qualify our judgments. They won't significantly alter them. Consider now the American war in Iraq, where the intention was regime change and democratization, presumably, and also the winning of material and strategic advantage. It can't be said that the attack of March 2003 forced the people of Iraq to defend the state that protected their common life. There was no common life under Saddam Hussein. Iraqi Kurds welcomed the attack and wanted the Americans to stay, still want them to stay, until their own autonomy or independence is secured. Shiites in the South had no reason to defend the Ba'athist regime, but mostly wanted the Americans to leave as soon as possible after its overthrow. Large numbers of Sunnis resisted both the invasion and the subsequent occupation, but it wasn't the common life that was at issue, but rather the old regime and their dominant role within it. Only the Americans, it might be said, really believed that there could be a common life for all Iraqis and a democratic and secular regime to boot. And that belief stemmed as much from ignorance as from idealism. That's a very powerful argument against the invasion. The imposition of risk is already wrong, but the wrongness is greatly intensified if the people imposing the risks have so little understanding of what the risks are. Still, the overthrow of a regime as awful as that of Saddam Hussein doesn't fit the moral meaning of aggression. But this was not a regime that most Iraqis were prepared to defend. It's only after its overthrow that they, or many of them, are ready to risk their lives in the name of one or another vision of a successor regime. Germany, Poland, and NATO Yugoslavia might be considered as polar opposites. The first represents the worst kind of unjust war, a war of aggression. The second represents the best kind of just war, a war fought in defense of others. America-Iraq falls somewhere in between, in my view, closer to the unjust pole, and so establishes a rough continuum, along which we could mark out other positions, perhaps many others. Think, for example, about wars like the Falklands War in 1982, the Israeli invasion of Lebanon that same year, the American attack on Panama in 1989. None of these would get high grades on a moral scale. None of them seems to me an example of aggression. I can't give a moral description or a name to all the possible kinds of wars that will require a more creative linguistic craftsman. I've only attempted a rough description of two of them. But the existence of a moral political continuum invites lawyers and legal scholars to mark out a continuum of their own, a range of illegal uses of force and a range of legal uses also. Surely this is a work that has to be done before the ICC can think about prosecuting political leaders for the crime of aggression or for any lesser crimes. There are a lot of people in Europe mostly, but also here, who want to begin the prosecutions, though I'm not sure they have a clear idea of what they are prosecuting, even when they are very clear about whom they want to prosecute. I've never been sympathetic to what the Chinese call the rectification of names, which doesn't seem to be anything more than a new way for government officials to tell lies. Still, my claim in this talk is that the moral and legal judgments that we make every day, or again that we should make, require a certain kind of linguistic revisionism. Not rectification, perhaps, but multiplication. We need a richer moral and legal language so that we can make more nuanced and differentiated judgments. It's not that we can't do that now. I've been trying to do it, but it can be done better. A better language of condemnation and approval would lead to more accurate perceptions of the moral world. Or, since accuracy will always be contested, it will lead to better arguments about what we and everyone else are doing and should be doing in the moral world, which is the real world. This is the first case. I think I would not give up the Nuremberg precedent. Maybe the definition, I think the definition is adequate, but the case is very clear. And we need to do a kind of, I don't know that we have the court system now to do it, a kind of casuistry. We need to work through a series of cases. If Roger thinks that the American war in Iraq or in Panama is a war of aggression, he has to tell us why, and we have to have an argument about that. And then we have to talk about 20 other cases. And when we see how the cases line up, we will begin to understand what aggression is.
The time has come to reach a decision now about creating this court and giving them authority to deal with the crime of aggression. They will consider all of these points, which are valid points. You'll write your law books and your books about them, and I hope they'll read them, because they should be taken into consideration. And then they will reach a conclusion, which, whatever it is better than what we've got now. Because now you have a hegemon doing whatever they please, jeopardizing the security and safety of the whole world, while we sit and continue to talk. Is it another 65 years? I won't be here. I don't think any of you will be here. So I urge you to please put your support behind the International Criminal Court acting now. If you want arguments to support it, they're on the table there. I'll give you one. I don't have too many.
And you have a couple books too then.
Who should do it if not the ICC, and when?